This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we'd like to speak about the duty to defend again, where the duty to defend was required for the named insured but not for an additional insured, because the named insured was not claimed to have been negligent. A casino owner, unhappy with the quality of construction on its new casino, sued its general contractor and others in Maryland State Court. The general contractor filed a third-party complaint against the subcontractor, and that subcontractor's insurer filed suit in the United States District Court for the Southern District of Florida, seeking a declaratory judgment that it need not defend the general contractor and subcontractor. In a case called the Cincinnati Specialty Underwriters Insurance Company versus KNS GROUP, LLC, GM&P Consulting and Glazing Contractors et al., a decision of the USDCA for the 11th Circuit rendered on October 6, 2022, the 11th Circuit entered a Solomon-like decision, making some happy and others not. The parties in this case came together to build the Maryland Lives Casino and Hotel in Anne Arundel County, Maryland. Tudor Perini Building Corporation, the general contractor leading the construction project, hired GM&P to provide exterior glazing for the building. GM&P in turn enlisted subcontractor KNS to assist it by glazing glass and installing window walls. The parties signed a contract on June 5, 2017, in which KNS agreed to take out, maintain, and pay all premiums for commercial general liability and other types of insurance, and to indemnify GM&P for liability for damages to people or property caused in whole or in part by any act, omission, or default by the subcontractor. KNS acquired commercial liability insurance from Cincinnati for the relevant period. The policy covered losses due to property damage, which it defined as physical injury to tangible property, or loss of use of tangible property that is not physically injured. The policy included as an additional insured any party that KNS, the named insured, provided in writing that it would insure under the policy. The policy warned, however, that it would cover those additional insured parties, quote, only with respect to bodily injury, property damage, or personal injury and advertising injury caused in whole or in part by 1. The named insured's acts or omissions in the performance of its ongoing operations for the additional insured, 2. The acts or omissions of those acting on the named insured's behalf in the performance of its ongoing operations for the additional insured. On June 25, 2020, a lawsuit called the Underlying Action, brought by PPE Casino Resorts Maryland, LLC, the casino's owner, against its general contractor and subcontractors in the Circuit Court for Anne Arundel County. The state court complaint alleged that GM&P installed a defective glass facade that has loose gaskets between window panels, damaged sealants and panel frames, and misaligned window wall panels, creating the risk of property damage. PPE asserted that GM&P's negligent furnishing of materials and negligent installation of the glass facade was a breach of GM&P's duty to PP&E to complete the facade in a safe manner and without causing property damage to PPE or creating the risk of property damage. GM&P responded with a third-party complaint in the underlying action against KNS and 2 other third-party defendants that played roles in the construction process. In it, GM&P brought claims against KNS for breach of contract and negligence due to KNS's alleged defective construction of the casino. In July of 2020, Cincinnati sued in federal court seeking a declaratory judgment that it had no duty to defend and no duty to indemnify KNS or GM&P in the underlying action. The Circuit Court of Appeal opined that an insurer's duty to defend an insured in a legal action based on Florida law arises when the complaint alleges facts that fairly and potentially bring the suit within policy coverage and does not require delving into the merits of a case. The court analyzes the duty to defend by comparing the allegations in the complaint with the language of the policy. An insurer need not defend an insured party if a policy exclusion applies. If an insured satisfies its initial burden of showing that the policy coverage applies, the burden shifts then to the insurer to prove that the loss arose from a cause which is accepted. The court concluded that Cincinnati's additional insured endorsement does not provide coverage to GM&P. The policy limits GM&P's coverage to bodily injury, property damage, personal injury, and advertising injury caused in whole or in part by KNS or KNS's agents. The complaint in the underlying action alleges that GM&P was negligent in its furnishing of materials and installation of the glass facade. It alleges no negligence by KNS nor any of its agents. Without more, Cincinnati has no duty to defend GM&P in the underlying action, nor, moreover, does Cincinnati have a duty to indemnify GM&P. There is a clear difference between caused and caused in part by. The latter term means that even if the complaint alleged KNS was only 1% responsible for causing the faulty workmanship, then Cincinnati would have a duty to defend GM&P. Cincinnati must, of course, defend KNS in the underlying action, because all doubts as to whether a duty to defend exists in a particular case must be resolved against the insurer and in favor of the insured. An insurer is required to offer a defense in the underlying action unless it is certain that there's no coverage for the damages sought by the insured party in the action. The complaint in the underlying action alleges that the glass facade supplied and installed by GM&P and other entities, including Tudor Perini and CI Energia Solar SASES Windows, is fraught with systemic defects, including loose gaskets between window panels, damaged sealants in panel frames, and misaligned window wall panels, creating the risk of property damage. In turn, GM&P's third-party complaint says that if proven, the alleged property damage was the fault of KNS and or its agents. The policy includes a breach of contract exclusion, and that exclusion provides, quote, this insurance does not apply to any claim for bodily injury or property damage arising directly from or indirectly from breach of express or implied contract, including breach of an implied in law or implied in fact contract. This exclusion does not apply to liability for damages that an insured would have in the absence of the contract. Cincinnati, therefore, has a duty to defend this entire suit if any claims fall within the scope of coverage, because PPE's complaint in the underlying action includes allegations that plausibly fit within the policy's definition of property damage and plausibly are not captured by the policy's exclusion. Cincinnati has a duty to defend KNS in the underlying action. Of course, the claim for indemnity is premature. The district court's assessment that was premature to rule on Cincinnati's duty to indemnify KNS for any damages that it might be liable for in the underlying action was appropriate, since indemnity depends on evidence not present in the current set of motions. Therefore, the 11th Circuit concluded, 1. Summary judgment in favor of Cincinnati on the basis that it has no duty to defend or indemnify GM&P Consulting and Glazing Contractors, Inc. in the underlying lawsuit. 2. Summary judgment in favor of KNS on the basis that Cincinnati has a duty to defend KNS. And 3. Affirmation of the trial court's decision that it is premature to ascertain whether Cincinnati has a duty to indemnify KNS. In my opinion, the 11th Circuit, unlike the litigants, read the full policy and reached the only logical decisions based on the evidence before it. The named insured was entitled to defense because there was property damage and no applicable exclusion. The additional insured was not entitled to defense because the property damage was not alleged to have been caused by the named insured. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who cares by clicking on zelma.com/blog. Please subscribe and you'll be advised of all future videos and all future blog postings, and also consider subscribing to my locals community and my Substack publications. And click like at YouTube and Rumble, and click on the Rumble button at rumble.com if you view this video at rumble.com. Thank you for your attention.